This is Sobiya from Law Info. IC Golaknath and ORS versus State of Punjab and ANRS. Equivalent citation 1967 AIR 1643 1967 SCR 2762. Petitioner IC Golaknath NORS. Respondent State of Punjab and ANRS with connected petitions. Bench Subbarao KN Wancho M Hidayatullah GC Shah SM Sikri RS Bachawat. V Ramaswamy JM Gillette Vishta Bhargava J.K. Mittal and C.A. Vedarangam. Date of judgment 27 Feb 1967. Whether a parliament can amend a fundamental rights enriched under the Part 3rd of the Constitution of India by invoking Article 368 of Indian Constitution for the first time came into question in Shankari Prasad versus State of India, where the constitutionally of First Constitutional Amendment Act 1951 was challenged. Shankara Prasad, which just a start to what became the biggest legal battle with Indian democracy faced. The Pigs Code Golaknath case facts. The immediate fact of the case were that the family of one William Golaknath had over 500 acres of property in Punjab. Acting under the Punjab Security and Land Tenures Act 1953, which was placed in 9th schedule by the 7th Constitutional Amendment Act 1964, the state government intimated to petitioner that he can now only possess 3 acres of land and rest will be treated as the surplus. Agreed by this intimation of the state government, petitioner filed a writ petition under section 32 of the Indian Constitution. Under Article 32 of the Indian Constitution and pleaded the violation of his FRs mentioned under Article 19(1)(f). For example, right to hold and acquire the property, 19(1)(f), right to practice any profession, and 14, equality before law and equal protection of law. Petitioner's argument number 1. The Constitution of India as drafted by the Constituent Assembly is of a permanent nature, and no act which changes or tries to bring about a change is constitutional. The word amendment only implies a change in accordance with a basic idea and not altogether a new idea. Number 3. The fundamental rights as provided under Part 3 cannot be taken away by any act of the Parliament of whatever nature because they are the essential and integral part of the Constitution, without which Constitution is like a body without a soul. 4. Article 368 only defines the procedure for the amending the Constitution. It does not grant the power to the Parliament to amend the Constitution. Number 5. Article 13(3)(a) in its definition of law, which cover all type of law, for example statutory, constitutional, etc. Its ambit, therefore, by the virtue of Article 13(2). Any constitutional amendment violation of Part 3 will be unconstitutional. Respondents' argument number 1. Constitutional amendments is a result of the exercise of sovereign power. This exercise of a sovereign power is different from the legislative power, which Parliament exercises to make law. Number 2. The very object of the amendment is to change the laws of the nation as per the changing needs of the society. The absence of such provision would result in constitution because too rigid. There is no hierarchy in the constitutional provision as basic or non-basic, and all the provisions are equal importance and equal status. Number 4. Most of the amendments being the answer to the political questions. They are outside the ambit of the judiciary scrutiny. Judgment. The apex court, which the largest bench that had ever sat on the issue, till that the time arrived at the 6-5 majority favoring petitioner. Then CJI along with the 4 other justices, Justice Shah, SM Sikri, JM Shelat, CA Vaidyanathan, wrote the majority opinion, and Justice Hidayatullah, agreeing with the CJI Subbarao opinions, wrote a separate opinion where Justice K.N. Vanju, Vishta Bhargava, and G.K. Mittal wrote a single minority opinion, and Justice R.S. Bachawat and V. Ramaswamy wrote separate minority opinions. The majority opinion of Golaknath reflects the uneasiness and skepticism in their minds about the courts of Parliament. Since 1950, Parliament, through invoking Article 368, have passed numbers of legislation that had is one pretend or another violation populous affairs. The majority was doubtful that if Sajjan Singh remains law of land, then a time would come when all the FRS adopted by our Constituent Assembly will be diluted through amendments and finally extinguished. Keeping this probable inhalation of FRS in the mind, fearing the gradual transfer of democracy into totalitarian Indian, majority overruled Sajjan Singh and Shankari Prasad. Therefore, to check this colorable exercise of power and shame democracy from autocratic actions of the Parliament, the majority held that the Parliament cannot amend fundamental rights. The majority equated FIRs with the natural rights and recognized them as the primordial right necessary for the development of the human personality. The majority raised a very serious question over the state that when rights mentioned under Part 3 cannot be affected by the Parliament Anonymous Bill, then how a simple or special majority can do so? On the other hand, the minority opinion followed the earlier law, for example, Shankari Prasad and Sajjan Singh, thereby holding the Parliament has the power to amend entire constitution, including fundamental rights. Therefore, the minority granted complete autonomy to Parliament. Reasons. The reason which promoted to the majority to arrive at the decision are as follows. Number 1. According to the majority, the impugned Article 368, throughout which the Parliament has drawing power to amend the Constitution, in fact merely lay down the procedure of the amending the Constitution. The majority relied on the marginal note of the earlier Article 368 to arrive at this conclusion. Number 2. The majority located the power to amend the Constitution in Article 248 of the Constitution, which provides for the residuary power of the Parliament, since the product of Article 248 in law. Therefore, in majority's opinion, amendment of Constitution in law for the purpose of Article 13(2) of the Constitution. The absence of the word amendment in the definition of law was answered by the majority in form of the definition under Article 13(3)(a). It's not exhaustive, rather it is inclusive. Number 4. Justice Hidayatullah, through the writing separately but agreed to CJI Subbarao on the point that there is no difference between legislative and amending process. The reason which prompted the minority to arrive at their stance are as follows. Number 1. Minority bench was fearful of the stance of majority in the sense that if the majority opinion because established law, then it was grant though rigidly to the constitution. There was skeptical that if the parliament is not provided with amending competence, the constitution would become static and all the dynamic nature of the constitution will meet death. Number 2. In accordance with the minority opinion, although the procedure for Article 368 does very much correspond to the legislative process, but it is different from the ordinary legislation. Doctrine of prospective overruling. The judgment inter alia provides for the prospective overruling of the law laid down by the judgment. The decision to the prospective overrule earlier decision was a smart and reasonable move played by the judiciary. The doctrine of prospective overruling implies that the effects of the law to be laid down will be applicable on the future dates only. For example, past decision will not be affected by the decision. The prospect overruling was chosen by the majority because of the following reason. Number 1. The majority, in order to save the nation from the chaos of respectatory operation and the judicial branch for the multiple litigation that may follow after the decision, opted for the prospective overruling. This was in order to minimize the negative impact of the judgment invalidating the earlier constitution amendment. Number 2. Another reason because of which the majority opted for the prospective overruling was since the decision in Golaknath was that Parliament cannot amend the fundamental rights, therefore all the previous amendments would be invalid and unconstitutional. Aftermath of the Golaknath case. On April 7, 1967, just 2 months after the Golaknath judgment, Nath by PM from the Rajapur constituency introduced a private member's bill into Parliament to indirectly overrule the decision. However, the bills failed to reach the floor of the House. Critical analysis. The decision in Golaknath led to the emergence of two schools of thoughts, namely vindication of fundamental rights. Number 2. Hindrance in socio-economic legislation.